Hi everyone, this video discusses the new office aspect of the L-1 Intracompany Transfer Non-Immigrant Visa category. Please visit jqqlaw.com to access more extensive information about the L-1 program. For specific legal guidance about your case, please consult with an experienced business immigration attorney. My name is John Khosravi, and I'm the managing attorney of the JQK Law Firm. My law office has had great success in obtaining its immigration visa category and status for our clients. I will start with an overview of the program and then go into narrower aspects of the new office category. What is an L-1? Generally, the L-1 non-immigrant status permits the transfer of certain executives, managers, and specialized knowledge employees from a foreign company to a related U.S. entity. What is a new office L-1? The new office category for an L-1 visa under the regulation 8 CFR section 214.2L is when the U.S. office or company has been doing business in the U.S. for less than 1 year. Why would a company want to or be required to open a new office L-1? This option allows a foreign company to send certain employees to the U.S. to get the U.S. company started before it has actually become fully operational. Importantly, newer companies that are not fully established may be required to file as a new office L-1. What is the difference between a new office L-1 and a regular L-1 for an existing office? A new office permits a somewhat lower standard as to how developed the U.S. office is for the initial approval. Also, a new office beneficiary gets 1 year of initial status as opposed to up to 3 years for an existing office beneficiary. Note that the employee or employees coming to the U.S. must have been in an executive, managerial, or specialized knowledge role abroad for 12 continuous months in the last 3 years before petitioning, and to be in one of those roles while in the U.S. Also note, specialized knowledge employees abroad cannot come to be a new office executive or manager, but can continue as a new office L-1B specialized employee and worker in the U.S. From what time do you begin calculating the company's start date to be able to fall within the new office category? Normally, it starts on the date the U.S. company is registered and/or starts its business activity. However, if the business has been existing for more than 1 year, it may still be a new office if regular, systematic, and continuous provisions of goods and services only occurred less than 1 year before the date of the filing of the L-1 petition. This is established by looking at the number of employees, date of entity establishment, the gross and net income of the company, as well as other documents related to business activity. What additional evidence do you need to show to qualify for a new office L-1? The U.S. company which acts as the petitioner of the foreign employee must show that it is prepared to commence business and will be established enough to sustain the business and the foreign employee's position in the U.S. within a year of their arrival. There are 2 important things that must be shown. 1. Evidence should demonstrate a realistic expectation that the enterprise will be able to start upon approval by showing a properly registered company having a federal tax ID number, corporate registration, bank accounts, required licenses, etc. B. A realistic, detailed, and comprehensive business plan that includes the amounts invested, personnel structure, product or service to be provided, and financial projections as well as other information. C. The appropriate intended nature of the work of the employee that is coming to the U.S. And 2. The petitioner must have sufficient physical premises to house the new office before submitting the L-1 petition. An important note here is that the regulations do not specify the type of premises that must be secured by a petitioner seeking to establish a new office. The phrase sufficient physical premises is broad and somewhat subjective, leaving the United States Citizenship and Immigration Services, also known as USCIS, great flexibility in adjudicating this legal requirement. There may be cases in which a residential premises or home office would satisfy the regulatory requirement. However, the petitioner bears the burden of establishing that its physical premises should be considered sufficient as required by the regulations at 8 CFR section 214.2 L3 5A. What should you prove to show sufficient physical premises? A. This means having at least the minimum office space required to house the employee or employees. Normally, a virtual office or PO box are not permitted, although I have heard anecdotally of virtual offices being successful. I wouldn't try it myself. B. Best practice is to show enough space, office or other commercial type, to house the company, including the necessary staff and other physical needs according to the detailed entity structure and financial goals listed in the business plan. C. It's best to have a lease for a minimum period of 1 year. However, I've had 6-month leases approved. E. Using residential property as opposed to commercial property as the office is not recommended, but if planning on doing so, make sure to document that the zoning ordinances, licenses, and property lease agreement permit the type of commercial activity being done. Include the lease agreement, floor plan, and exact square footage of the premises and pictures to show the ability to house the activity in the petition. Include bills such as internet and phone line, and it's best to have the landlord include a letter explaining their knowledge of the situation. Extending L-1 status after the first year. There is no provision in USCIS regulations that allows for an extension of the new office for more time. If the business does not have sufficient staffing after 1 year to relieve the beneficiary from primarily performing operational and administrative tasks, the petitioner is ineligible by regulation for an extension. However, an established company will be able to get up to a 2-year extension. It is important to develop the company's U.S. staffing levels to justify the need and ability of the foreign employee in the U.S. to carry out his or her duties at the level required. A petitioner also has to show the qualified and related company abroad is still doing business with the same corporate relationship as before. Note that it may be possible, though difficult, to get an initial 3-year L1 even if the petitioner is a new office. If the petitioner can prove with great evidence that the U.S. company is or will be very established and fully operating in the first year. Also, there have been cases where a 1-year new office L1 was extended for additional 1 year to help the company further establish itself. However, these situations are rare and case specific. Also note, for employees that are also owners or majority stockholders, in some cases, evidence of the intent to return to the home country should be provided. Finally, information on previous visa applications should be consistent. The transferring employee's work history in the L1 petition should be consistent with that which was listed on any previous U.S. visa applications. Thank you for listening. For detailed information about your case, please contact the JQK Law Firm to schedule a consultation. Our contact information is available at jqqlaw.com.